Hey y'all, this is Professor Tracy back with another contracts video. This one is an introduction to remedies. So the last few lessons we've been looking at breach and related topics like conditions and anticipatory repudiation. And now we're looking at sort of the goal here, right? Which is to get a remedy for our clients. So let's get right to it since there's quite a bit to talk through. So we're going to first look at the theories of recovery. So we're going to cover all the different possible theories of recovery, and there are three interests when we think about remedies. So one is an expectation interest, two is what's called a reliance interest, and three is restitution. And these are words that we've thrown around throughout all the lessons that we've covered, but we're going to look at those words in the context of remedies in particular. So when we are thinking about what is the plaintiff's desire, in other words, what's motivating the plaintiff in each of these contexts, if they're seeking an expectation recovery or a reliance-based recovery or a restitution-based recovery, what's their desire? Under expectation, it would be that they wish that the other party had done what they had promised to do, because expectation is meaning put me where I expected to be. Reliance interest instead is saying put me back where I was before I had the misfortune to rely on the promise you made to me. So it's I wish I had never contracted with you in the first place. And restitution interest is saying I wish you would give back to me the value of that I have bestowed on you, whether that's the value of the service or the good or the property, or we'll see that it could be giving back the very thing that has been bestowed on them. So here, what is the approach that we're taking with each of these interests? If we have an expectation-based recovery, then we're looking to the future and trying to put the plaintiff where she expected to be. Whereas reliance, we're looking to the past and we're saying, what expenses did that party incur in reliance on the promises that were made to her? And can we give her the money to put her back to where she was before she relied on this promise? And restitution is saying, in what way is it that the other party, the defendant, has been unjustly enriched, and we then seek to disgorge from the defendant the value that has been bestowed on them, by which they've been unjustly enriched. And so when we are talking about each of these interests and the approaches and the motives, we then need to think, well, what is the remedy that's typically given that furthers those interests? So with expectation, it will be money damages or an order of specific performance. We'll unpack all of these in more detail later in the lesson. For now, we're just introducing these concepts. So with reliance, it is typically the person's out-of-pocket costs that we're giving. With restitution, we're giving that party either a monetary restitution, which is what we have typically thought of as restitution throughout all these lessons, or specific restitution, meaning give back to me the good or the property that I bestowed upon you. Meaning not money equating to the value of it, but the thing itself. So when we think about these questions here, these are questions from material that I provide to my students. So the purpose of contract remedies is to do what? Remember that contracts isn't about punishing somebody or seeking to reward them. Instead, it's just about compensating for losses. So the answer here would be B. So question 2 says, which of the following is a correct statement of the law regarding the three interests, expectation, reliance, and restitution? Here, that the reality is you can have a remedy that is based on more than one of these interests. The typical thing would be to only reward on one, which is what C says, but in some situations, a court may choose to blend remedies together, and we'll talk about why they might do that. So the answer there is C. So with question 3, we talk about expectation interest. What does it seek to do? Well, we've already talked about this, that A says puts the non-breaching party in the same position as if the contract has never formed. No, that's not correct, right? That would be a reliance recovery. So that means B has to be the answer, and indeed it is, because we're saying we want to put the non-breaching party, the injured party, in the same position they would be in if the contract had been fully performed. So B gets at that answer. So here is this question. We're looking at something more broad here, and we're going to look at a couple different parts of it. So here, the question reads, painter enters into a contract with owner to paint owner's house for $5,000. So the contract price is $5,000 by November 1. Painter projects the total cost for the job are $4,500, which includes supplies, salaries of his employees. Consequently, painter expects to make a profit of $500. So the math is done for you there. Not that it's super complicated, but it's done for you there. Painter purchases some of the supplies and begins the job. When painter has painted exactly one half the house, owner unjustifiably terminates the contract and insists that painter leave. At this point, painter has spent $2,500 on supplies and labor. None of the unused supplies can be reused on another job. Owner then contracts with contractor to finish painting the other half of the house for $3,000. So painter and contractor are of equal skill, and $3,000 represents the fair market value of painting half of owner's house. So here, if we're asking what are painter's expectation money damages, but let's back up, because let's nail down who's the plaintiff, who's the defendant, because that's important to know. So the breaching party here, it says owner unjustifiably terminates, right? Owner unjustifiably. So owner is the defendant, they are the breaching party, and the injured party is painter. Painter is forced to leave the job without having finished the job and being paid for the rest of that job. So what are painter's expectation money damages? Well, to know that, we have these three interests. Right now, we're looking at expectation and expectation money damages, but we need to know how to calculate them. So how do we do that? Well, when we're looking at this, there's a couple things to say. Is that one, when we're thinking about expectation money damages or just the expectation interest generally, this is by far the most common basis for recovery, and it gives the plaintiff what's called the benefit of the bargain, meaning the benefit of the bargain that they made with the defendant. They're getting the full benefit of that by being put monetarily, if it's money damages, putting them where they expect it to be. And it is, as we've already said, it's future looking. We're looking forward and we're saying, where is it that they expected to be? Now, we're saying, okay, in order to calculate expectation money damages, we need to know if both parties fully performed, meaning if they fully perform, where is it monetarily that the plaintiff painter expected to be? And what I'm going to show you here, and this may seem kind of, sort of simplistic, but I'm going to use a number line approach, and I'll explain it more in a second. But the reason I have this language here where it says $0 is the starting point is that I'm using essentially a number line approach where 0 is where we would start when we're thinking about where is it that the plaintiff expected to be, and then where is it that the plaintiff actually is. Our starting point is always going to be in the middle of that number line on 0. It's called the comparative method of calculating expectation damages, and it is perfectly legitimate. There's nothing nothing elementary about it, but it essentially works on a number line. And I will visually show you that here in just a second. So where would Painter have been? Remember, the contract price was $5,000. So he would have expected to receive $5,000 from owner and to have spent or to have paid out $4,500. We're getting that just from the facts themselves, which told us that. So we would expect that at the end of this, that Painter would be $500 up, that they'd have a net gain of $500, having received $5,000 from the owner, but having spent $4,500, their expected money position ultimately would be a positive $500. So we can map this out on a number line like so. So the starting position is going to be 0 because that's how we do this when we are using the comparative approach. So then, right, so that was our first step, our starting money position, 0. Realize I'm just estimating that I'm not doing any sort of exactness of where I'm marking these things. Obviously, that is in the middle. But in terms of the things I'm later going to mark, don't look at this and go, well, it's not perfect because it doesn't equal the same distance on the number line or whatever. That's not the point. I'm just trying to illustrate it for you so you can see it. So what we're going to mark now, the second thing, it says Painter's position if the parties had fully performed. Well, we said he would be positive $500, right? We just showed that he would have received $5,000 but spent $4,500. So that's the expectation interest there. That's where they expected to be. Painter would have been up $500. What's their actual money position? Meaning, as things unfolded and there was a breach, where is it that they actually were? With only half the job done and receiving no money from the owner. So we're told in the facts that what do they actually occupy? That's what we're taking a break here and deciding, well, what position do they actually occupy? We would start at 0 again and say, how much did they receive of the $5,000 that they were supposed to from owner? 0. How much did they spend? The facts told us that they had spent $2,500 for supplies and the salaries of employees. So that means that there's $2,000 that they would have spent that they didn't, right? Which we can say, okay, that's an avoided cost. So we're accounting for that, and you'll see how. But here, their actual money position then, having received nothing and having spent $2,500, is a negative $2,500. So we can go back to our number line and go, what's their actual money position? It's a negative $2,500. So then we say, okay, this is a comparative method. So we are subtracting the actual position from the expected position. So, which you'll see us do that, right? Here you can visually see, right? We're asking with expectation money damages, how do we get Painter from where he actually is to where he expected to be? And it's pretty obvious if you look at this. We can say, well, it would take $2,500 to bring them back to 0. But they expected to end this contract to be at $500. So we need to give them another $500. So we can add those and say that's a positive $3,000 to put them in their expected money position, right? That you can see that visually why that's true. Another way you can think about this and why it's often called the comparative method is that you say, what's the expected position? Well, it's positive 500. What's their actual position? It's negative 2,500. That we're subtracting, right? They're subtracting the 2,500 from the 500. If you subtract a negative, two negatives make a positive, you would add, right? So that would give us the $3,000 the same way. So that's just comparative, comparing the expected position to the actual position. We subtract, and then we get to the same number. So $3,000. So what are his expectation money damages? $3,000, right? We can see it right there. Well, what about though, why not just give the full? It would certainly be simpler if we could just say, well, give Painter the $5,000 contract price. And that would be simple, but what if we did that? What if we did that? Well, realize what it would do. It would be saying, okay, half of the 5,000, 2,500, puts them back to zero. But then if the full 5,000 would mean what? That we're giving another 2,500, right? Because 2,500 plus 2,500 is 5,000. So if we gave 5,000, that would overcompensate them, right? Because they would then be put in the position of being positive 2,500. So that means they would be overcompensated by $2,000. So that is why we don't do it. We're not trying to give the painter a windfall. We're not trying to give them, a prize or to punish the other party. Contract law, for the most part, does not do that kind of thing. So for instance, there are no punitive damages, those kinds of things. We're not doing that here. So we're trying to put them compensate for losses, and that's it. And if we were to give straight up the contract price, they would end up overcompensated by $2,000. So that's why we don't do it. Right? This is just an explanation in writing of what I just said to you. So I will move on. What are Painter's reliance money damages? Now we're looking at this second interest of reliance and saying, what about reliance money damages? Well, we already said that the reliance interest is about out-of-pocket cost, compensating the plaintiff for her expenses. And we'll talk about, well, why would you ever do that? Go for reliance recovery rather than expectation. We'll talk about it in a minute. But here, when we look at this, remember what it is. We're trying to wind back the clock and say, let's put the plaintiff back to where she was before she made the mistake of relying on the defendant's promises. And so we're saying, what expenses did she incur in reliance on the contract? So here, why are we doing it? I mentioned this just a second ago. Why do we do this? Why, oh why would you ever get a reliance interest recovery? Typically, it'll be because there's some problem with proving what your expectation money damages are, and we'll talk about where that might come up, like being able to if you cannot prove them with certainty or they're speculative, then you cannot receive expectation money damages. You would have to shoot for one of the other things. Then the other place would be if you're using promissory estoppel. So those are the two places you would typically be able to get or would seek a reliance recovery. Now, keep in mind with promissory estoppel that reliance damages are not the only damages you could ever possibly receive. The court can limit a plaintiff's recovery under promissory estoppel to reliance damages, but they could and also give the plaintiff the full value of the promise, meaning expectation damages. But the court has discretion. It's an equitable cause of action. They can say that justice here requires a limitation of the remedy, that the plaintiff should not get the full value of the defendant's promise, but just be limited to reliance damages. So here, if we go back to the fact pattern with painter and owner, well, what would the recovery be here? Remember what we would be doing. We're seeking to put the plaintiff back to where they were before they expended money in reliance on the promises coming from the defendant. Here, if the starting point, again, number line approach, comparative approach, we use 0. The only expenses the facts tell us about that the painter incurred are $2,500. So those are their total expenses out of pocket. So it's pretty easy to map out reliance money damages in this fact pattern. We can say our starting position is 0, then we can say, well, what is the amount that they incurred in reliance on that? We said it's $2,500. So we can put it back, mark it out there. And then we're not trying to put them where they expected to be, but only to cover their out-of-pocket expenses, to put them back to zero where they were before they relied on this. So that would mean giving them $2,500. That covers it. So pretty straightforward, right? With Reliance money damages here. So here's a question that's interrupting us as we go through the various possible recoveries for Painter. But Reliance interest, what is it? We just talked about it, that it puts them in the same position as if the contract had never formed. Does it put the breaching party in that position? No, it doesn't. It puts the non-breaching party in the same position as if the contract had never formed. So the answer should be B. So the answer is B there. Now, what about the third interest, which is restitution, a restitution-based recovery? How do we do that? We're calculating the value of the benefit conferred on the other party. And if it's monetary restitution, which is what we have in view in this question, rather than specific, then it's money, right? It's money. We're talking about a money recovery here. And we are looking at what is the value that has been bestowed on the other party. And similar to Reliance recovery, we're going to do this when they might be suing in restitution, or again, there might be a problem with damages that they're uncertain or speculative, or they weren't foreseeable. If we're talking about consequential damages, that there's some reason they may not be able to recover them. The other thing is, if the contract has been rescinded because of a defense, then restitution is your only avenue of recovery. There's no way to recover expectation damages because there is no contract on which to recover. All you can do is sue for some sort of other cause of action like restitution. So restitution, how do we calculate it? We're going to look here again. We said there's monetary, there's specific. Those pretty straightforward. But how do we calculate it here with painter and owner? Well, conveniently, the facts tell us the value here was $3,000, right? So now keep in mind, I'm making a big deal of this just because we're asking, to what extent has the owner here been unjustly enriched? What extent has the defendant received the benefit for which they have not paid? And so that's why we're focused in on it, right? Because that's what we're concerned about here is what have they received? And we're told by the facts that $3,000 represents the fair market value of the house. So the value that has been bestowed on there, or the fair market value painting half the house. And you might say, well, that means his work was actually worth $6,000 and he was only going to get $5,000. And the answer is yes, but that's okay. People make contracts all the time that don't exactly mirror the market value of their labor or their services or the house they're selling or whatever it may be. So don't get hung up on that and be like, well, that can't possibly be right. No, it is right because the question tells us it's right. So we know that we know from the facts that exactly one half of the house was completed by painter. So the benefit that was bestowed on owner was one half of the house being painted, and we're told by the facts that that's worth $3,000. So we know that that's the value that has been bestowed on them and for which they have not paid. So here, pretty easy if we map this out on a number line. Again, the owner's starting position is 0, but then once this has been conferred on owner, the painting of half the house, they're up $3,000. And once they're up $3,000, we know how much they paid for that? Nothing. They haven't paid anything back representing payment for that value they've received. So in this case, it's straightforward. We can say it's $3,000, right? In order to write the scales, right, to move it back to 0 here with any sort of reliance recovery, then we need to give the $3,000 to Painter to represent that. So when we ask what's the restitutionary money damages, it would be $3,000. So that's just words saying what we just said. So I want to focus in primarily on the expectation recovery or an expectation-based interest here. And when we talk about that, there are two, right? We said there are two common remedies that are based on this expectation interest. One is specific performance. Two is money damages. We've talked some about money damages, even shown how you might calculate it. But there's more to say. With specific performance, one could say, well, isn't that the perfect remedy because it's an order from the court that is requiring the defendant to perform exactly what she was supposed to under the agreement. So it's giving the plaintiff exactly what she expected. So in that sense, it looks perfect, right? Well, how does it work? Well, one thing to know up front is it's not always available. We'll talk exactly what needs to be shown. And here, these are the two most common. I probably state that wrong, a little too broadly or too definite here to say these are the only two instances, because generally available in the word only there are a little bit in tension. It would be better to say it's generally available in two instances and take out the word only. These are common places where it would be ordered, would be a real estate contract where, because we view land as unique, so giving someone money to go buy some other piece of land rather than one they contracted for is deemed to be inadequate, that's not an adequate remedy. So instead, they are given, and they can get an order of specific performance requiring, for instance, the seller to convey the property to them. And then if we're under the UCC and we're talking about goods, then anytime you're thinking of something that is unique, like some sort of fine art or rare, some sort of rare goods, if it's a special order item or antiques, sort of one of a kinds or almost one of a kind things, then those are, again, giving me money to go buy something else isn't going to be helpful because this is the thing that I wanted. So an order of specific performance makes sense. Now, when you talk about if I'm seeking an order for specific performance, then I need to show three things. I need to show that the inadequacy of money damages, in other words, giving me money, is not going to adequately compensate me. It will not be able to put me where I expected to be, or not entirely. And then that the terms of the agreement must be certain and definite, meaning that the court needs to be able to look at the contract and see enough detail. Now realize, do not look at this and go, well, that's the same thing as an offer. You wouldn't even have a contract if you wouldn't be this far if you didn't have certain indefinite terms. And the answer is no, you're wrong. That the certainty and the definiteness we're talking about here is of an even higher standard than what we're talking about with what's necessary to have an offer and to have an enforceable contract. Here we're saying if a court were to try to fashion an order of specific performance, is there enough there that they know exactly what it is the defendant should be ordered to do? Or is it left too vague or open for them to be able to order it and then for them to know whether or not the defendant is fulfilling the terms of the agreement? That's what we're getting at. So do not conflate the two because they are not the same. And then when we talk about feasibility, we're not saying, oh, is an order of specific performance something that we could actually draft on a piece of paper? What we're saying is it feasible for the court, for the judge, to oversee that, right? Do they have the expertise necessary to know whether the party is fulfilling the terms of that order of specific performance? And two, is it something that that given the constraints of if we're talking about judicial economy and saying, okay, there are scarce judicial resources, is it a feasible and wise use of those resources? Like, is it going to take too long? Is this going to require the judge to check in on this for 3 years or 5 years or 10 years or whatever it may be? or is this a one-off thing? And it's not necessarily meaning that if any of those things are true, that it requires multiple check-ins or whatever, then it's not going to be ordered, but it raises questions. So all three of those have to be proved. And so when is it that money damages are inadequate? So the one I talked about with property and with goods is the difficulty in procuring a substitute, meaning if it's a piece of property, every piece of land is unique, so giving me money to buy someone else is not really a substitute from the land that I wanted. That is very clear if you start thinking about, oh, this one piece of property is lakefront property. This other piece of property is in downtown in the middle of a city. Well, those are obviously not the same pieces of property. We can all agree, but we take that to be true in every situation with land. So there's difficulty in procuring a substitute. Or you could say, if it's unique, so if it's unique, whether goods or land, then procuring a substitute is difficult. But realize it doesn't have to be one of a kind. It could be something where it's like, well, you might be able to give me money to buy another one of these, say, these particular types of vases that are, say, mink vases, and there might be other ones, but the other ones that I might get are not of the same quality, or they are, whether that means substantially worse, or that means substantially better, meaning that you would have to give me substantially more money than the value of the one I had. So either of those kinds of things would all be about difficulty in procuring a substitute. The other part, uncertainty in money damages, is getting at something I've talked about already when we talked about reliance and restitution. If I cannot prove out my damages, my expectation money damages, then an order for specific performance might make sense. Now, that uncertainty could come in different ways. It could be that, it's just hard to know because it's not clear how much I would make, for instance, in profit, how much profit I would make, or it could be some other reason that it's speculative or difficult to nail down. Then unlikely to be collected is the idea that sometimes people are judgment proof. And if you're going to give me money, a judgment for money damages, that may not be of much value if in fact they're just going to go bankrupt. And so it may be better to order them to provide what it is they were supposed to, even if it's not unique, etc. So in looking at this, I already talked about what we mean by certain indefinite terms and the need for that in order to fashion an order for specific performance. And then feasibility is talking about expertise, things like that. So remember, before we go on, that what an order for specific performance is. It's an order from the court ordering the defendant to do what it is she was supposed to do under the agreement. If she does not, then there's the penalty is contempt. It's going to typically realize the penalty for contempt is typically either some monetary sanctions or sitting in jail till the person complies. So the other possibility, right, we just looked at specific performance and we talked about money damage, but we need to unpack it, right? We've talked about what it is, what we're doing. We're trying to put them where they would be if the party had fully performed. I've told you we're using a comparative or comparison method where we're comparing where they expected to be to where they actually are. And what's the basic formula? I mentioned this, but again, the starting point will always be 0, right? So I picture here, even if I am not laying out a number line again, there is an imaginary number line behind this where the starting point is the middle, it's 0. And then we're saying, what was their expected money position? Where would they have been if they had spent all the money they were going to spend to perform and receive all the money they were going to receive from the other party had they performed? Where would they have been? And then what is their actual money position after the breach? And we are comparing those by subtracting them, right? So that's why you see it there. And then that will give us our expectation money damages. But we need to break it down, right? That the starting position here, as I've said over and over again, it's going to be 0. And we're looking forward and saying, where did they expect to be? And figuring that. Here, I'm noting that realize there's some things that are included in expectation money damages that are what are called consequential damages. We'll talk about that in a second, and we're looking at the actual money position. And when we look at actual, we're looking at general, consequential, incidental. So, okay, when you think expectation money damages, there are three kinds. They are general damages, consequential damages, and incidental damages. Okay, there are three kinds. So how do we work this out? So here they are. The general damages part of it. The general damages part of it, there are two possibilities. Either what's called replacement cost or repair cost, replacement or repair cost, or the difference in value, the difference in value. So replacement or repair cost is we're saying, give me the money to, if it's a repair, if it's some sort of a contractor doing, say, a remodeling in your house and they botch the job and they do a crappy job, then the repair cost would be the cost to repair, meaning to put that job in the position I expected to. So give me the money so that it can be repaired, meaning repaired to the point that it's now the job I expected. So if they were remodeling in my kitchen and they botched it, then it's giving me money to pay somebody else to repair the crappy job, to put it in the position it would have been in. The other possibility, the way to think of it is replacement, right? It's the cost of replacing what was done, that thing that was done. So here, difference in value is the difference between what I expected to receive, the value of the good or the service or the land that I expected to receive, versus the value of what I actually received. So that's saying the difference in value. And with consequential damages, so general damages, this is important because I introduced general damages and said, well, it's usually like repair, replacement cost, or the difference in value. But what I didn't say is that when we think about general damages, those are the damages that flow in the natural course, naturally flow from the breach in the ordinary circumstances. So meaning whoever the plaintiff is, regardless of their circumstances, this would be their damages because they naturally flow from this kind of breach. Now realize when we say that, we don't mean that the amount would be the same regardless of the plaintiff, but that this kind of money, this kind of damage, that this loss is the kind of loss that everyone will suffer in this circumstance. But in comparison, consequential damages are those damages that flow from the plaintiff's special circumstances. So they flow from the special circumstances of the plaintiff. They are unique to the plaintiff, not meaning they're the only one in the world who, has this thing, but this is not the kind of loss that every plaintiff would have, but rather it's a kind of loss that is specific to this kind of plaintiff. And so with consequential, you want to think of, we look at this example to consider, okay, what's general, what's consequential. So here it says, Tracy enters into a contract with Tire King to purchase a set of 4 tires for his Honda Fit for $400. So $100 a tire. Tire King never delivers the tires. Tracy then locates a replacement set of tires for his car that cost him $500. What are my damages? Pause here a second. They're $100. You know that this is not hard, right? Because if I have to turn around and do this? Now think about this. What did I expect? Where did I expect to be? I expected to be $400 out of pocket, negative $400, and to have 4 tires. Where am I actually? I'm at negative $500, and I have 4 tires. So to put me where I expected to be, I need $100, right? I need $100 to put me from negative $500 to negative $400. So my damages are $100. So are those general? Are those consequential? Well, guess what? Anybody in this circumstance who is contracting for a set of tires and the tire provider, the seller, doesn't give any tires and they have to go pay somebody else more, will suffer damages. Will it be exactly $100 every time? No. It might be $50. It might be $200. It might be $75. It would be whatever the greater amount they had to turn around and pay. What's the difference between the greater amount and the lesser amount that they would have paid? But those are general damages. They flow from the breach and the ordinary circumstances, because everybody in this circumstance would have the same damages. As opposed to now, in the unlikely event that I'm actually running an auto repair shop, now it says this: he, that is Tracy, has a customer that needs a set of 4 new tires for her Honda Fit. Tracy enters into a contract with Tire King to purchase the tires for $400 and explains he needs the tires quickly so he can use them for a customer. Tire King never delivers the tires. Tracy then locates replacement set of tires for the customer, cost him $500. So far, those are general damages, just like the previous question. Anybody in that circumstance would have $100 in general damages. However, the delay in getting the tires meant that Tracy had to discount the amount he charged his customer. So he ended up earning $50 less from the customer. So let's think this through. Where did I expect to be? I expected to be $400 out of pocket and to have $50 extra from the customer, right? To have $50 more than I ended up with. So, but I'm not there. Where am I? I'm $500 and down 50, right? So I'm $500 out of pocket. So so here you could say, well, I guess the better way to talk about the $400 part would be to say, I didn't expect any discounts. I just expected $400 out of pocket. So that would be where I was. But then where am I? Well, I'm $500 out of pocket plus I'm negative $50 by having to cut in to give a discount. So this discount here, right, is consequential damages. They flow from what? They flow from my special circumstances. Not everybody who has a contract with Tire King for a $400 set of tires is also an auto repair shop and has a client that they might have to knock off money for because of the delay. So we'd say $100 general, $50 in lost profits here is part of the special circumstance. Those are consequential. So here, question 6, what is the correct statement? General damages arise from the ordinary circumstance. That sounds good. Consequential arise special. That sounds perfect. Let's go with A. So let's look then here. It says consequential damages. Here are a bunch of examples of consequential damages. They are flowing from the breach, but they are flowing from the plaintiff's special circumstances. They are additional losses, monetary losses. And these are the typical kinds of things you would say, like lost profits, meaning exactly what it is. Money I expected to make that I'm not going to be able to make. Liability to third parties, meaning let's say you're a supplier and I run a factory and I'm assembling cars, you're sending me tires, and if you breach the contract, I may have to breach contracts with the, say, car dealerships that I am selling my cars to. So that would be a liability to a third party. Injury to person or property, that because of the breach, not only was there just direct monetary loss, but there was an injury, right? There was something wrong with the property, there was something wrong with the good, there was something wrong with the service that was done that caused injury to me or injury to my property. That whatever loss, injury, medical expenses, etc., related to that, maybe things that I can get as consequential damages. Loss of use is often so if I, for instance, let's say you're supposed to remodel my entire house and I have to be out of the house for that, then that I have a loss of use there. If you breach and take, say, 6 months longer than it's supposed to, then loss of use there would typically be measured by, it would be what? Well, I've lost the use of my house for an extended period of time because of you. And we would measure that typically by what is it that it costs Tracy in order to cover that loss of use. So if I had to rent another place, what was the rent? Then it might be, instead of liability third party, that liability is not to like my customer, a car dealership, but basically liability government, that because of what has happened, you have knocked me out of compliance, I'm being fined, or I have some sort of fee that is I need to pay. So here I'm looking at sort of how do we categorize each of these types of consequential damages. Well, if it's lost profits, that's money I expected to make but did not make because of your breach, right? Lost profits would go under my expected money position because I expect. But everything else is go under my actual money, right? Because it's money I had to pay out because as a result of your breach. And so it's like, well, my actual money position is this. Not only did I lose this amount of money because of your breach, but I also was liable to a third party. I also had injury to person or property. I also was liable to the government. I also lost the use of this, right? So let's keep trucking here. What are the limitations on consequential damages? Well, they're really, I throw that out there because this is often where these limitations come up, but realistically, limitations that we're talking about here, let me talk about them briefly. We'll talk about these, but the limits that exist on damages, are some of them more likely to occur in consequential damages? Yes, and the biggest one would be foreseeability, because when we talk about consequential damages, remember that you're saying it's unique to the special circumstances of the plaintiff. And when we talk about foreseeability in the context of contracts and in the context of consequential damages, what we're saying is that that loss that the plaintiff is seeking as consequential damages must have been foreseeable to the defendant from formation of the contract. And that foreseeability, though, can come simply from the plaintiff explaining that if the defendant breaches, that this is the consequence. So it doesn't, it can just be literally told or spelled out at formation. And the most famous case here is Hadley versus Baxendale when you're talking about the shaft for the grain mill. And when that is the broken shaft, so it's an Old English case. And the problem that arises in that case is the shaft in the mill breaks that runs the mill. And it's the only shaft they have. And so when they give it to the courier is supposed to send it to the people who are crafting a new shaft so that they have one to go by to know how to craft this shaft for the mill. And they don't say anything to the courier about if you're late, if you're delayed, our mill's going to be shut down longer or whatever. And so instead, the courier is unaware that with any delay, that means they're shut down another day and they're not making any money. And so the courier ends up breaching the contract by being delayed, and it does result in the mill being delayed. But the court ends up saying, well, the profit you would have made, that consequential damages, those flow from the special circumstances here of they're running a mill and they don't happen to have a spare shaft for the mill, and so they had to be shut down. And so those were not foreseeable. They are not foreseeable because they're not something that just naturally flows from the ordinary circumstances that everybody. So ordinarily, general damages, foreseeability is not a big problem. Is it still a requirement? Yes. But because it flows from the ordinary circumstances and it's likely that anybody in that circumstance would do it, it's usually just common sense that, of course, the defendant knows that. Whereas consequential damages, that's not the case because they're unique to those circumstances. So in Hadley, when the courier didn't know and wasn't told, had no way of knowing, those damages aren't recoverable. So the other limits we'll see on consequential damages are they need to be proved with certainty, and there needs to be causation, meaning that the plaintiff needs to show that the breach is what caused those consequential damages. And there, typically what's being used is just simple but-for causation. And if there are multiple but-for causes, much like torts, then you're just asking, well, was it a substantial factor? So here, lost profits will always be classified as consequential damages. And here, you just need to be careful because they may be, they may not be. In part, it depends. They could be general damages because sometimes the profit somebody expects to make is built into is just straight up built into the contract. It's not sort of one step removed. And we'll see some examples of that in a second. But they could be general, they could be consequential, and if they can't be proved with certainty, or they're not foreseeable, or there's no causation, well, they ain't going to be anything, right? So, but here, what this question is actually intending to get at is the idea that sometimes the profit is built in to the general, it will be part of general damage. So if you think back to the painter and the owner, he expected to be $500 up, and that's his quote profit. He would have spent $4,500 and received $5,000, but those aren't consequential damages. Those are the general damages that exist in that case. So lost profits would be something more removed from that, like my question with with Tire King and me running an auto repair shop. And here's an example too. It says buyer and seller enter into a contract for the sale of Blackacre at a price of $100,000. At contract formation, buyer informed seller that the reason he was entering the contract was to purchase property in order to build a fast food franchise. So he's told, right? So foreseeability is kind of built in here. Buyer informed seller the reason he was entering the contract was to purchase property in order to build a fast food franchise. Seller repudiated the contract at a time when the fair market value of Blackacre was $120,000. You just got to go with that. Buyer immediately terminated the contract to sue for breach. As a result of the repudiation, buyer had to find a new location for the fast food franchise, and his plans to start the business were delayed. Buyer lost about $30,000 in profits from the sale of fast food during the 3-month delay. So here it says, what are general damages, what are consequential? Well, the general damages here are, this is for the purchase and sale of a piece of property, okay? And so where is it that buyer expected? If we just focus first on the property itself, not the $30,000 in profits that are also being claimed, we would look at this and go, okay, $100,000. They expected to have spent $100,000, so to be out $100,000, but to then have an asset that was worth $120,000. So the value of the property would have been $120,000. So we're measuring the gain they expected to be then at a positive $20,000. Out $100,000, but up $120,000. So that would put them at a positive $20,000. So they didn't get the property at all, right? So their actual money position, as far as we're concerned with the general damage, would be zero, right? Remember, so we're saying where would they expect to be? They're at zero, they expected to be at 20, so we give them $20,000 to put them at a positive $20,000. That under general damages. So $20,000, and anybody in that circumstance, right? Those flow from the ordinary circumstances, from the breach, but here, the unique thing here is that the property was going to be used in order to build a fast food franchise. And so this $30,000 in lost profits is consequential, right? In this fact pattern, it's consequential because the general just relates to the purchase and sale of the property itself and where the buyer would have been. So the 30 here is consequential, it's foreseeable. Why? Because the buyer specifically informed the seller at formation about the purpose of it. Realize there are facts here we don't have, which is normally they would still have to prove with certainty that amount. That might be difficult unless they have some track record they can show that that net number makes sense. But that would be assuming they could prove it, and obviously it is causation there. We can say, but for the breach, they would have been able to open on time and made that during the 3 months. But whether the only open part of that, I guess, is certainty. So we can look at this, right? This is, if we're using our formula here, right, we can say this is, so if we back up, using my formula, right, this comparative method, we said they expected to be $20,000 up. So $20,000 in general, expected general, $30,000 in lost profits. Their expected money position was $50,000. So we know this is general damages, this is consequential damages. So where are they? They got none of that. They had zero. So to get them to 50, we would need to give them a total of $50,000 with 20 of it, as we said, being general and 30 of it being consequential. So incidental damages, typically what we're talking about here are expenses that are incurred in order to mitigate damages or to deal with the breach. And even if those efforts are uncollectible, or not uncollectible, even if those efforts are unsuccessful, they can still be collected. They can still be collected as long as they were reasonable. So here you can see an example. On December 1, employer-employee enter into a 1-year employment contract for an annual salary of $200,000. The start date for the employee is January 1 without justification. Employer anticipatory repudiates the contract on December 15. So it's the employer who repudiates. Because of the short time period, employee hires a job coach at the cost of $1,000 to help him find a replacement job. The $1,000 fee is the fair market value for a job coach. It's telling us it's a reasonable expense. It's a reasonable attempt to mitigate. Because of the job coach, employee finds another employer willing to hire employee for a year. However, the new job pays $150,000. So we have here, there are no consequential damages listed here, but there are general damages, right? We can say, let's focus on the general side of it first, which is the expected money position. Okay, let's focus on what was the expected money position here. It was to be up $200,000 at the end of the year. And so if we were to just map this out, right, we could say, okay, 200, where are they actually? They're getting $150,000 for the year. So their general damages are $50,000, right? So to get them from where they are, their actual position with regard to their general damages to their expected would require 50 grand. Then the $1,000 is part of their actual money position. It's incidental damages they expected to, incidental damages that they incurred, because they did it to mitigate or to deal with the breach. We're told that it's reasonable and therefore it's recoverable. So their total damages would be $51,000. So 50, they're not both. So we got a multiple choice question dealing with this. It says that's incidental, the 1,000 for the job coach, then 50. So B looks like the right answer. Yeah. Limits on expectation damages. So I've mentioned these. They have to be proved, all damages, but have to be proved with certainty. That is often more likely a concern with consequential damages, as is causation. But does it flow naturally from the breach? Another way to say that, remember, is that we use but for causation. If there are multiple causes, then we would use, much like torts, substantial factor. So with foreseeability and predicting the future, we said that it must be something, if If it's general damages, then they're likely foreseeable because they flow from the breach, and they naturally flow from the breach. They're ordinary circumstances. But they must be foreseeable from formation, and if it's something like consequential, then becomes a much greater concern because it's less like they're not automatically foreseeable. Then mitigation is to the extent that your loss is caused by your failure to mitigate, then that's not recoverable. So that's it, except that's not it. We're doing a question here. If a damage award appears to be overcompensating a plaintiff, how might a court limit the award? They could do any number of things, right? They could say a portion of it is not certain or not foreseeable, or that there's no causation. Any of those are possibilities. And even though the question is worded that way, I'm not sure that would be the entire reason they would do that. I think it's more likely they're limiting it because there's legitimately a problem. So what about question 11? If a breach results in a gain to the non-breaching party, i.e. they're put in a better position than they would have been had the contract not been breached, then what will a court likely do? So if they're getting a windfall, if the non-breaching party is already in a better position, then what will we do? Well, it says offset the non-breaching party to keep the gain since they're the innocent party. No. Split the gain between? No. Offset the gain against the damages owed to avoid compensation. That sounds right, that we would offset. So if they've already had some sort of gain, then we would offset that against whatever award they're going to get. It's possible if they had a huge gain, it would wipe out any potential money damage because they're actually in an okay money position. So that's it. Finally, that the lesson is complete, but very much looking at and doing practice problems is important. Hopefully it was helpful. I know it was long, and I know it's kind of technical and tedious, but it's a very important topic. If it was, please do give the old thumbs up and hit the subscribe button. It means a lot, and I appreciate it very much. So I will be in touch with more, and I'll talk to you again soon.